Hi folks, you're with Tacitus today, your pushback channel, and thank you for joining this audio live stream. Please listen to this presentation as you would a radio broadcast. In this essay, I'd like to talk about the recent decision by the United States Supreme Court by just a 5-4 vote, much closer than I thought it would be, but to decide in favor of the Trump administration's policy of deporting criminal gang illegal aliens who have been, as I understand it, guilty of some sort of crimes, murder and that sort of stuff. Now, a district court judge, an activist judge, I mean, it's hardly an impartial judge, but an activist judge blocked that effort by the administration to deport these illegals. But a lot of the sort of legalese and the litigation got caught up in the weeds rather than dealing with the headline issue, and I think that's sort of been lost a little bit in the frenzied media reporting, really on both sides. There's some of the stuff I've seen that the 5-4 court vote was crushing victory. There's no crushing victory. If it was like 7-2 or 9-0. Vote, then that would be a crushing victory. But this idea of 5-4 is a crushing victory, no, it's not. That was a very close run thing. Now, on the face of it, you say, well, deporting illegal gang criminal aliens that are not even shouldn't be in the country anyway, and they're criminals, and like what's is there any decision need to be made here? Why would anybody oppose that or question it even? But that's sort of, there's a bit more to it than that. Be it activism or not, some of the queries made by the original judge, I think it was Boasberg, who in my view at least is a rabid activist and should have recused himself from hearing the case. And the activist, litigators, purposefully picked him as being a judge who would decide in their favour, which again should in itself be a basis where the judge has to recuse himself. When the activists say, the screaming radical activists say, we want him, we want him to make it. That alone should be a basis for recusal, or for the other side of the litigation to say, we're going to have to get another judge here, guys. The idea that the activists can pick another activist to make a decision that they want, that they've already pre-written, that's not use of the law. That is blatant lawfare. But anyway, coming aside from that, there are various sub-issues that really didn't get much in the way of headline attention, and it's worth just having a little, not a deep dive, but it's worth just having a little look at some of these. Now, one of them is how do you determine who a gang member, illegal alien isn't tough, but how do you determine who a gang member is? How do you determine that they've committed crimes? Because they're going to be sent to maximum security prisons in maybe not even the country of their origin, but like people from Venezuela being sent to a prison in El Salvador or something, that sort of thing. So the query is, are these people getting due legal process? Are they, because it's not simply just deportation, it's deporting to a prison. Are they getting due legal process? Have you proven conclusively that they are members of the gang? What evidence has been tested in a court? How can you prove that they have murdered X amount of people? And is it something that's been held to a high standard of evidence in a court of law, that you prove that yes, Raul is a gang member and Raul has killed how many people, murdered so many people? Is that, do you have that verdict proved conclusively in a court, and have these people got that level of due legal process? Now, these are the same judges, by the way, that have no problem throwing people into prison for January 6th. Insurrectionists, Nazis. Well, don't they? Shouldn't they have to go through a very high burden? Shouldn't the government have to meet a very high burden of proof? No, they're Nazis. They're straight white male Nazis. No, prison for them. So The duplicity here is outrageous in my view. That on one hand, the January 6th type people, or people that are praying outside of abortion clinics or that sort of stuff, they can be thrown into prison, stuck in solitary. Their due legal processes and rights, that nobody cares. Who cares? They're Nazis after all. Who cares? But whereas these, they're illegal aliens anyway. They're supposed to have the highest of high burden of proof standard has to be met before they can be deported. So I don't accept that, but that's the position. It's okay when we get rid of people's legal rights, but you can't do it. And it's that same thing we see from the globalist controlled leftist activists all the time, be they judges or anyone else, prosecutors, FBI, and so on. So that's one thing. Should the state have to meet an exceptionally high burden of proof before being able to send these folks off to some prison in, I don't know, Guatemala or El Salvador, wherever it might be. So now the claim that Boasberg and some of the other judges around, the activist judges around are saying, well, these people haven't been afforded due legal process to a very high bar of evidence. And it has to be the highest of high bars. When you want to lock people up for January 6th, it's the lowest of the low bars. You don't need any evidence that they were somewhere in the Washington vicinity at that time. That's all you need to throw them in prison. But with these guys, you've got to have the highest of the high bar. I don't accept that an activist group can just arbitrarily and rando determine that you have to meet a super high bar of evidence. Nonetheless, that was part of it, not the only, but part of the argument there. Have you proved that they've committed? Have you proved that they're members of this or that gang? Now, the administration is saying, well, look, they're illegal aliens, and on the balance of probability, they're gang members. Now, they may not be gang members. They may not have committed any murders. So the concern is that given the low bar of evidence, that innocent people may be swept up in the dragnet. So that is a real issue, by the way, and I don't sort of denounce that as irrelevant. But again, it's the inconsistency. Why is such a low bar of evidence needed to go after January 6th people or people you don't like? But just because you want to, shit and annoy the Trump administration, suddenly it has to be a very high bar of evidence. That I don't accept, and I don't accept that activist judges should be making these decisions, or that they should be able to impose nationwide injunctions on an elected government. So that's part of the thing. Now, the next to bypass some of the lawsuits, as I understand it, to bypass some of the obstructive lawsuits, the Trump administration used the 1798 Alien Invasion Act, which I think was signed into law by the then President John Adams. That's how long ago it was. And it was, reasonable at the time and probably not unreasonable. It was used again, during, wartime and that sort of thing. And it's almost the right to suspend the writ of habeas corpus, but it's applying to aliens, not to citizens. So there's a distinction there to be made. Even so, the next part of the lawsuit that the Supreme Court needed to consider is that act valid, or a valid way of, bypassing other restrictions that otherwise may exist? Is it a valid way of deporting people? Now, are these people actually criminal aliens? Again, it comes back to what arbitrary powers does that confer on the president, the 1798 business, confer on the president, and are those powers, should they be permitted in any way to bypass due legal process, or to minimize or dilute due legal process for somebody so accused or about to be deported? So there were, sub issues to do with that. What if someone's, not part of a criminal gang? They may be an illegal alien, but what if they're not part of a criminal gang? Should they just be deported, but not deported and imprisoned? How do we distinguish between the two? So there were some sub issues here to consider. Use of arbitrary power, these sorts of things. And should they have had some sort of scrutiny? Well, I guess, I'd rather there was a legal oversight, but the problem, or the trouble as I see, is that there's just too many activist judges, too many activist groups bringing the matter to court. Too many activists involved all around, and there's not enough people looking at actually the law and what it means. Fortunately, the Supreme Court, or at least the 5 men on the Supreme Court, determined that it was legal, but it was a 5-4. All the women voted against it. Women on the Supreme Court, voted against it. So it was a close run thing, and so no great victory in my view. Now, I don't know how many people are going to be involved in this, as in how many people caught up in the dragnet. Is it possible that people that are maybe, say, illegal aliens but not gang members, but they have committed murders, or a murder or a crime, or they've they're not gang members but have committed crime. They are gang members but haven't committed, that sort of thing. So the burden of proof. What would the burden of proof need to be on those sorts of things? Does anybody know? Because it would break out all these cases into separate case by case. If everyone had the right to litigate it, they'll all get free legal aid and litigation to litigate it, be they gang members, mass murderers or not. So then the government, the Trump administration, would be put into the hopeless position of having to litigate each case by case. Which would be what the activists want. It'll hold things up. It'll just gum up the works and so on. But so now they can go ahead and deport these people. I think in the overall scale, given the tens of millions of illegals that are in the United States, it's going to be very, very difficult if every single person, 100% due legal process. Where will the money come from? The amount of courts and the time involved, it would substantially gum up the works. So if you're an illegal alien, you need to leave. And this is, again, where I think the fault line of legal contest will be. But it is, if it says that every illegal person has the full right to American standard of full due legal process justice, again, something that was not afforded to the January 6th people, for example, then the administration's positioning, a role in deporting all those illegals would be impossible. They'll be lucky to get rid of 1 million a year at that rate, lucky to get rid of that many. And at the moment, they're running, they need to be deporting 15 to 20 times more people than they currently are if they're going to get anywhere near reaching even a majority of the illegals, deporting them. So these are the wider stakes, and if you like, the political, geopolitical type tactical machinations that are going on in background. But should the Supreme Court have reviewed some of the things? I think so. Given the amount of sub-issues to be considered, was it appropriate the Supreme Court had a look at? I believe it was. Should it have been 5-4? No, I don't think so. But they do raise a fair point. But consistency is the issue. Why wouldn't the Supreme Court jump into the middle of the January 6th protesters being imprisoned? Why did the Supreme Court want nothing to do with that, but they would buy into this? Why is there no consistency? Why are legal rights of illegal alien murderers considered more important than American citizens over January 6th? These are some of the wider issues we should be talking about. You've been a Tacitus today, your Pushback channel, and thank you for listening.